Thank you very much, Reverend Hall, and thank you warmly to Intimate Conviction for this invitation that deeply honors me. I'm also thankful to Bishop Elena for his sharing his considerable wisdom with us today. I have, of course, prepared my presentation on the basis of the mandate's stock of knowledge as it stands in the body of international human rights law. But I would like to start these brief remarks by sharing with you my experience as independent expert appointed by the United Nations Human Rights Council to make visible the way in which violence and discrimination manifests itself every day against lesbian, gay, bisexual, trans, and otherwise gender or sexually diverse people around the world. It has been remarkable to me in the last 3 years how many times I have received the information, testimony, or life experience from people that I talk to around the globe, in which they express to me that one of the deepest wounds that they feel in their life experience is the explicit or implicit message that their sexual orientation or their gender identity prevents them from being spiritual beings. That because they are gay or lesbian or bisexual, they will not have the possibility of reclaimed spirituality, or because they are gender diverse or trans, the idea of transcendence is something that they can actually not aspire to. This is deeply troubling to me, because I believe that in Bishop Selene's words, there is something very human in understanding spirituality as a fundamental part for seeking happiness. And so I am delighted at the holding of this conference that explores the relationship between religious thinking and law, and in particular, the processes of decriminalization that, in my view, are fundamentally important for the deconstruction of stigma that is fueled every day around the world by processes of criminalization, pathologization, and demonization. Crime, illness, and sin, a triad that must be explored in the deconstruction of stigma. I feel privileged to be part of this conversation, taking part during this exceptional conference, also because events where activists come together to share their knowledge and build joint global voices are evidence of the vital role of civil society in the processes of eradication of violence and discrimination. And I believe this is ever more important in times where deliberate actions are being taken in different corners of the world to reduce the space of civil society. We must bear in mind that, like any other human rights movement, all significant developments in this path that we are following have had the contribution of the live forces of society, human rights defenders, persons with lived experience, and civil society organizations, and oftentimes have been born within its womb. Now, the resolution that creates my mandate, the mandate of the independent expert, requests me to address multiple intersecting and aggravated forms of violence and discrimination that are faced by persons based on their sexual orientation and their gender identity. And it is clear to me that analyzing root causes of violence and discrimination requires a multi-dimensional assessment of all factors, including historical, sociocultural, political, and anthropological, having concurred to create a certain understanding of what is perceived as a norm in relation to gender, sex, and sexual desire. In that equation, faith is a fundamental component of that analysis. And in other words, while the mandate does not at all intend to speak the language of theology, it will include this language in its analysis of how these narratives contribute to the creation and in the cases that we're examining today, to the upkeep of particular strands of legislation. Now, my mandate seeks in that manner to be interdisciplinary, but it also is mandated to be intersectional. Intersectionality describes, of course, the dynamic processes in which distinctly unique life experience occurs. It varies in relation to the many identities that we unite in one body. And that include dimensions of ethnicity, language, nationality, race, socioeconomic status, sexual orientation, sex, gender identity, experience of disability, and many other factors. But it also varies in relation to time. We will be the first generations to face dilemmas associated with large numbers of aging LGBT persons who have built free and open lives within their communities and will face care and retirement systems that are unprepared or insensitive to their needs. We will be also at the crux of addressing medical questions deriving from long-term use of hormones of anti- or antiretrovirals, both statistically significant factors within the gay and trans communities. These experiences of intersectional experience also vary in relation to space. Experiences of violence and discrimination are absolutely different if one lives in the city or in the rural space, and persons are oftentimes forced to leave their families, their communities, and their countries as a result of violence and discrimination based on sexual orientation and gender identity. Now, the mandate that I have the honor to hold exists at the point of intersection of many of these perspectives. And I recognize the complexity of these existential and political points of departure and all the dynamics that are connected. I am, however, persuaded that within the compressions and tensions of this landscape resides extraordinary energy and potential to bring about constructive change. Now, other approach of the mandate is that of dialogue, and I'm supposed, of course, to be working across the board with a widest possible range of stakeholders. Now, there are limits that I have identified to this dialogue, and one of them is the fact that I have drawn the conclusion that legislation, public policy, and jurisprudence that criminalize same-sex relationships and particular gender identities are in and of themselves contrary to international human rights law. I have further gathered, analyzed, and established evidence and established the finding to the effect that this legislation fuels stigma, legitimizes prejudice, and exposes people to family and institutional violence and further human rights abuses such as hate crimes, death threats, and torture. And on this sense, treaty bodies and special procedures have, in fact, a well-grounded and robust body of evidence and legal analysis that started in the 1984 examination of Tunen, the case in which the UN Human Rights Committee ruled that sexual discrimination, that sexual orientation, is a protected category under applicable anti-discrimination principles. An approach that, of course, has been then taken forward in the work of human rights treaty bodies and specialized procedures, which have expressed concern about laws in the countries that criminalize consensual relations between adults of the same sex and that discriminate against persons on grounds of their sexual orientation and gender identity. What I think can be extrapolated on the basis of legal thinking from this body of work is that the execution of any sanction that is based on such measures is a violation of international human rights law. The deprivation of liberty is in fact akin to unlawful detention, and the imposition of the death penalty is an arbitrary killing in breach of Article 6 of the International Covenant of Civil and Political Rights. In that manner, it is sufficiently explored and proven that no historical, social, cultural, or religious sensitivities can justify criminalization of sexual orientation and gender identity. This has been further affirmed very recently by the report issued by my colleague, the Special Rapporteur of Freedom of Religion and Belief, in which he noted that states that maintain laws criminalizing consensual same-sex relations have in fact occasionally referred to religious justifications for maintaining them. And after a process that involved a vigorous consultation spanning from the Middle East and North Africa, South and Southeast Asia, Sub-Saharan Africa, throughout the Caribbean and the Americas, he noted the fact that these justifications are in fact contrary to the body of work of international human rights law. Now, not only taking point of departure, as Tunen did, in the idea of privacy, but much more vigorously grounded in the recent international and comparative law development gathered in the superb ruling of the Indian Supreme Court and rulings as well issued in Trinidad and Tobago and Botswana, in which a strong connection has been drawn between freedom from criminalization and the very idea of freedom that fundaments as a principle all human rights constructions, and the idea of dignity that lies at the philosophical foundation of the seeking of happiness and the ability to live free and equal lives as fundamental pillars in the human rights machinery and framework provided by the United Nations human rights framework and regional frameworks such as the Inter-American Human Rights establishment, to which, of course, many of the Caribbean countries are, all I would say Caribbean countries, are relating to. Now, the Special Rapporteur of Freedom and Religion and Belief requested and called upon states to examine their current criminalizing provisions and dismantle criminalizing provisions by not allowing the justification on religious grounds in connection with this. And I think that the construction, theoretically, the theoretical construction that was carried out by the Special Rapporteur to this effect is in fact the idea that freedom of religion and belief has several dimensions to it. And when you read his report, you realize that what he identifies are two particular dimensions that create legal implications on this fact. One of them is, of course, the ability and the right not to be discriminated on the basis of religion. But a second one is, of course, the idea and the freedom not to be discriminated on the use of religious arguments as such. And I think this report creates an important body of evidence and legal thinking that will assist all persons that are involved in this work of trying to understand these important dynamics that I think Bishop Elaine was capturing so well within the thoughts that he shared with us earlier on. Now, indeed, we all know that the process of decriminalization is a forward-moving process that has gathered significant energy over the last couple of decades. In the last 25 years, some 30 countries from all regions have taken steps to decriminalize same-sex relationships between consenting adults. We all know the examples of, as I mentioned, India, Botswana, Trinidad and Tobago, and in the African country, Angola and Mozambique, closer to my region at least, Belize is another example of decriminalization. In some countries, it has been the judiciary that has opened the way for decriminalization through landmark decisions on specific cases. And in other countries, it has been materialized by actions of parliament and the executive branch to review, in particular, public policy or the criminal code. But we all know as well that there are omnipresent gaps in this panorama. 69 countries still criminalize same-sex relations. 9 of them are in the region of the Caribbean, and many others, of course, in the African and Asian region. I believe the last count was that 35 countries in the African continent criminalize. Of those, 40 countries criminalize same-sex relations between lesbian and bisexual women and other women who have sex with women. And as we know, the death penalty may and is indeed applied in a number of countries in the African and Asian regions, in total 9 countries. The reality is that when we know the staggering number of 2 billion people, that's almost a third of the world population, lives in criminalized environments, and this demands of us active work of continuing and ensuring that this dismantling of criminalizing provisions will be a work that is actually completed. Now, I wanted to also mention that, of course, in several countries, laws also specifically criminalize transgender persons based on their identity or expression. Some countries criminalize cross-dressing, while many others criminalize different forms of gender identity and expression through often vaguely defined laws, leading to various human rights violations of transgender people, including arbitrary arrest and detention. Now, the violation to human rights occurs even when criminalizing provisions are not enforced. It has been abundantly proven that arrests and detention on the basis of sexual orientation are, of course, to be considered arbitrary, but also, indeed, that the very existence of the law leads to a number of connected violations, including, of course, ill treatment, in many cases torture, blackmail, threats, and other forms of violence. Now, there are other laws and policies of a more indirect nature that might also be negatively applied to certain groups and persons. They include laws based on public decency, public health, and security, at times in the guise of local criminal laws and regulations. For example, transgender women are often targeted and prosecuted on the basis of laws criminalizing sex work. Now, it should be noted that even though legislation is not applied and deploys all of these aspects, the non-application is a stepping stone to mitigation in the situation. But our intent is to ensure the prevalence of human rights through a situation in which all of this legislation is basically declared null and void. To this end, my mandate has made a call for a world free of criminalization by 2030. I see no reason why this objective should not be achieved. The data concerning Sustainable Development Goal furtherance and eventual achievement will be always polluted, in my view and in my assessment, in criminalizing environments. And I therefore think that there's a coherence of establishing that particular goal for the year 2030. Dear friends, as I said at the beginning, this invitation is a great honor for me. I am delighted to be part of this conversation. I'm further delighted because I am a firm believer in the importance of understanding the connection between these different narratives in ensuring this most human of aspirations, which is seeking happiness, the pursuit of happiness, utilizing in that all of these dimensions of the human existence. To that effect, I am delighted to remain in the conversation today, and I do wish you great success with this conference. I am convinced that it will be a very, very important building block in the construction of new solutions, new answers, and new narratives in this work of analysis, deconstruction, and eventual eradication of violence and discrimination based on sexual orientation and gender identity.
Victor, thank you very much for that. I'm sorry it was interrupted, but the spread of your presentation was truly remarkable. Two things struck me. One was your reference at the beginning to spirituality, and it occurred to me that no one has the right to impress their spirituality on another. Our relationship with God is an intensely personal thing. I'm with St. Paul on this one. We must seek our own salvation in fear and trembling, and that's our business and nobody else's. The second is your reference, obviously, to human rights law. There seems to be a lack of understanding that international law of any kind is a higher law than the law of any particular state. Granted that there may not be tribunals to enforce that law, but nevertheless it's there. So often it's thought of as interference. It's not interference. It's the reference to those higher norms by which ultimately we're all governed. All right-thinking people are governed. Otherwise, we're just a lot of selfish individuals who couldn't care a jot for anybody else. In 2013, the bishops of this province met together and came back and said, the Commonwealth and Britain are blackmailing us. And what they said was they're blackmailing us to have same-sex marriage. That was untrue. What they were trying to impress upon Barbados and other Caribbean countries was the issue of decriminalization. Britain didn't even have a same-sex marriage at that time. So you see how words can be twisted and situations can be twisted to suit the present agenda. So thank you very much for that broad, wide-ranging paper. Thank you very much. Well, and I hope you'll stay with us for the question and answer. You've intimated you will, so thank you for that. We move on now to the panelists. There are three in this first panel representing particularly Barbados. The Reverend Ian Rock and Alexa Hoffman and myself. And I have been scheduled as the first speaker. So yes,